Good afternoon, everyone, and welcome to the second webinar of the Water Rights webinar series, brought to you by the Socio-Economic Rights Institute, together with the Mail and Guardian and End Water Poverty. Today's webinar is entitled Water Services on Farms, the Role of the Municipality. My name is Kelebogile Kuno, and I'll be your facilitator today. I'll be assisted by Lisa Chamberlain, who will be managing the chat box, as well as Edward Mulopi. The series of webinars is based on SERI's Claiming Water Rights in South Africa research project, which examines how water rights are being claimed with a view to drawing lessons from the work of communities and civil society organizations in a diverse range of circumstances. 2 weeks ago, we launched the first webinar, Expropriation as a Tool, the Marikana Experience, which explored the lessons learned from the Fisher case. And discussed, amongst other topics, the use of expropriation to secure tenure and access to municipal services on privately owned land. Today, we'll shift the conversation of securing access to municipal services from the urban context to the rural context, as we look at the struggles of farm dwellers in the uMgungundlovu District Municipality to access water and other services on privately owned farms. So just some historical background. According to the Institute for Poverty, Land and Agrarian Studies, PLAS, farms provide homes for approximately 3 million people in South Africa. But who are we referring to when we speak about farm dwellers? It is important to distinguish between the different categories of people who live on farms in South Africa. Many people live on farms, but do not work on those farms. Many people work on farms, but do not live on those farms. And many people, of course, do both. What distinguishes farm dwellers is that they have historic ties to the land, beyond any labor relations which may exist. Farm dwellers have lived on the farm, on the land for generations. And as one farm dweller put it, we were here before the farm. After the 1913 Native Lands Act, hundreds of thousands of Black people were forcibly removed off farms. Those who were allowed to remain on the land were allowed to do so in exchange for free labor. This category of people are who we refer to as labor tenants. Due to this history of dispossession, farm dwellers remain one of the most vulnerable and isolated populations in South Africa. Farm dwellers have insecure tenure rights and are at risk of eviction. Some farm dwellers also report deplorable living conditions, including insufficient access to adequate water supply, to sanitation services, and refuse collection services. In 1997, the Extension of Security of Tenure Act, ESTA, was enacted to secure the tenure rights of farm dwellers and to prevent arbitrary evictions from their homes on farms. However, it does more than this. ESTA, together with the Land Reform Labor Tenants Act, known as the LTA, provides farm dwellers with statutory rights to land, albeit unregistered land rights, which coexist with farm owners' registered property rights. In this webinar, we'll be talking about the question of provision of services to farm dwellers living on land that they do not own, on privately owned farms. Thus far, farm dwellers have been rendered invisible, and until very recently were excluded from municipal plans. But who bears the obligation to provide services on farms? Is it the municipality? Is it the farm owners? Or is it the farm owners with assistance from the municipality as intermediaries? This has been a question which farm dwellers in the uMgungundlovu area and Afra have been grappling with for many years. Their biggest struggle has been that farm owners claim that the provision of water is a municipal responsibility. Municipalities, in turn, argue that even if they wanted to, they have no jurisdiction to provide services on privately owned land. After a long journey of engaging with farm owners and several municipalities, Afra and farm dwellers in the area assisted by the Legal Resources Center, approached the Pietermaritzburg High Court to claim their rights to water, sanitation, and other essential services in the uMshwathi case. To help us to understand the challenges farm dwellers, both Esther occupiers and labor tenants face in terms of tenure security and access to water and other services, and to unpack the lessons from the uMshwathi case, we have on the panel today Siyabonga Sithole, who is the Land Rights Program Coordinator at AFRA. He will be speaking about the context and challenges faced by farm dwellers in KZN in terms of tenure and access to water and other services on privately owned land. After Siyabonga, we'll have Mlungisi Mncwabe, a member of the Siyanqoba Rural Transformation Forum, and he will be telling us about the work and activities of Siyanqoba and about the hopes for the future of farm dwellers and their ability to access water and other services. Mlu will be assisted by Samke from AFRA, who will be assisting with translation. After Mlu, we'll have Simone Gray, who's an attorney at the LRC. She'll be talking about the uMshwathi case, sharing with us some of the legal strategies that were used, and we'll be speaking about the role of public interest litigation in realizing rights-based struggles. After Simone, we'll have our own Lisa Chamberlain, who is a senior lecturer at the Wits School of Law and was in fact the lead author in the Claiming Water Rights research project. And she'll be speaking about the role of a water services intermediary as a means to better understand the role of private landowners in water services provision. And last but not least, we'll have Sarah Smith from the Mail and Guardian, and she'll be speaking about the role of media in fostering a relationship with civil society to ensure that activists in rural communities are heard. We had invited a municipal official from the UMshwathi municipality, which was one of the respondents in the uMshwathi case, but unfortunately he was not able to join us today. So we'll begin with the four panelists, and each panelist will have about 10 minutes to speak. After the panelists present, we'll have a question and answer session where we'll actually start the session off with Kaya Sithole, who is an activist and political commentator on land rights. After we hear from Kaya and explore some of the questions from the Q&A, we'll hear from Sarah, who's from the Mail and Guardian, who will provide her perspective from a media perspective. And so before we begin, I just wanted to present you with a few housekeeping rules. So for the panelists, please remember to unmute yourself and turn your camera on when it's your turn to present. And for the attendees, you will see that we have a chat box, which Lisa has already put some messages in. And so please, as the panelists speak, should questions or comments arise, please feel free to use the chat to ask your questions. Lisa or Ed will collate these questions and will prepare them for the Q&A. So without further ado, I'm going to invite Siyabonga from AFRA to start us off. Thank you all for joining us today, and we're very excited for the panelist presentations that are coming up soon.
Thank you so much, Kelly. I hope I'm audible.
You are.
Thank you very much for organizing this webinar. And we really appreciate the opportunity to take part and share the work that's been done thus far around service provision on farms. Thank you for the introduction. So I am Siya Sithole. I know that my brother from another mother, Kaya, is also part of this space. So I hope we are not confused. I think the matter we're dealing with, it's a good starting point would be to elaborate on where you started Kilebogile, when you talked about who farm dwellers are. And I think your introduction really gives us a sense of who these people are. And the unfortunate part is that they, in our research and our engagements with them, when you ask them who they are, I think to put a point across, they now usually call themselves the forgotten citizens. And that is the context in which we brought this matter before the courts. Because we had a group of people here who are recognized by our constitution, but our laws and policy are just simply not seeing them, and therefore find themselves in a situation where, in some of their words, would say pre-1994 situation where they are a marginalized group, unprotected by law. This is why we then, in engagement with a number of farm dweller communities, where it started out by each, maybe individual households coming to EFRA, reporting issues around services where they could not gain access to adequate water or other services like sanitation, electricity, and so on. And we dealt with these matters on a case-by-case basis. And after a while, we soon realized that we would not have either the capacity to continue to work on an individual case basis, or we rather realized that the situation that is being reported is common across our project area. And talking to our sister organizations, like those that are part of this platform today, like uMgungundlovu, LRC, and many others, like SCLIC, the same was reported in other provinces, that there was a huge difficulty of farm dwellers accessing basic services. Now, the key question that we dealt with when we started out with this work was, why are farm dwellers any different from any other citizen in South Africa? As I think it was Archbishop Desmond Tutu who, when defending his relationship with the Dalai Lama, talked about or explained his relationship and defended it, and said that religion and affiliation in terms of religion is more a geographical accident. It is more where you find yourself. If you find yourself in the Middle East, you are likely to be a Muslim. If you find yourself in the Cape, you're likely to be a Christian. So in the same way, using that analogy, we then said to ourselves, is it fair that because people find themselves geographically in a space where they do not own the land, where we usually then say land is held privately, should those people then not benefit from the intentions of our constitution in terms of equality, in terms of shelter, in terms of, most importantly, dignity? And our answer, even before we went to court, was simply, it cannot be the case. We had to pull our resources together and find a way to get the courts to clarify that there is no way that private ownership can exclude South African citizens from attaining constitutional imperatives such as water. And that is the context in which we brought the case. And I think my colleague Simone will talk more about the actual findings of the court. But what we asked the court was, one, we wanted legal clarity. Who should provide services on farms? We wanted the clarification of Section 25 of the Constitution in terms of competing rights, in that landowners have constitutional rights, but so do occupiers on land. And in doing that, we worked with farm dwellers who reported many challenges, and services was just one of those challenges. It's the persisting subservient relationship on farms between landowners and farm dwellers. And as Kelly said, when I say farm dweller, I'm referring to farm workers, I'm referring to labor tenants, I'm referring to occupiers on farms. That subservient relationship between landowners and farm dwellers persists and continues to this day. The skewed power relations, as we've seen in media recently in terms of violence and criminality on farms, it is these skewed power relations and the subservient relationship and a lack of a relationship between these two groups that manifests itself in violence, criminality, and a lack of understanding of each other. We on farms today, majority of people are part of either community or household claims to gain ownership of the land that they are on. Those claims remain largely unprocessed or largely unsettled. And that is another factor that prejudices I'm sorry, I think I lost connection there for a while. I hope I'm back.
You are back. Thank you. You can carry
Thank
on.
you.
Yeah.
Thank you. Yes, so it's these situations that the lack of processing of claims prejudices both claimants and those that own the land in terms of gaining the necessary clarity to know what to do, whether to invest on the land, whether to sell. So again, government is playing a huge role, unfortunately, more often than not, adding fuel to fire here by not also doing what they need to do as government. Working conditions for farm workers largely remain how can I put it? We know that in the Western Cape, for example, the majority of occupiers there are farm workers. In KZN, the majority are farm dwellers. But the working conditions also have a huge problem. And we are working with the Department of Labor, CCMA, and other organizations to try and work on those problems. But unfortunately, the dire situation persists. And also, in conclusion, we work closely with the Rural Development and Land Reform and the newly appointed Office of the Special Master in trying to facilitate a process where instead of dealing with these individual rights violations that continue to take place on farms, that we try now and work in a transformative way where the idea is to advance and upgrade people's rights on farms so that they become owners. And therefore you change this relationship of master-servant or landowner, occupier, or employer-employee, you change that to simply neighbors, where our recommendation is that government should expedite the land reform program to ensure that farm dwellers, meaning labor tenants, meaning farm workers, meaning occupiers and their families, see themselves as owners of land on farms and therefore neighbors of landowners being landowners themselves. And for us, that will prevent a situation where today government still needs to go to a farmer and ask for permission or consent or access to be able to install services such as water, reticulation, or electricity. So this judgment, the Mshengu case, is the clarity that was needed, that it is a municipal obligation to provide basic services on farms. And I hope that my colleague Simone will further elaborate on that. And I hope I will also get the opportunity to maybe answer questions of clarity to move this conversation forward. On that note, thank you very much.
Thank you so much, Sia, for giving us the big picture and spelling out things for us. That was very helpful. So we'll now hand over to Mlu, who will actually be assisted by Mpumi from AFRA in terms of translation. Mlu, please take it away.
Sanbona, I greet you all. My name is Mlungisi Mncwabe from Orange Grove Farm. So with your permission, guys, I would like to
I think you're back, Mlu, so you can carry on.
Okay, yes.
Perfect, thank you.
Okay. 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 You hear me now?
Perfectly. Thank you. Go ahead.
Okay. As I said, my name is Mlungisi from Orange Grove Farm. So I would like to speak Zulu so that I can feel comfortable. Hello?
We can hear you. We can hear you.
Okay. Njengoba ngihlala eplazini elise Orange Grove, ngizithanda ukuchaza ngoSiyanqoba. uSiyanqoba ukuthi ufomeke kanjani uzofike kuleli zinga sokulona manje ubani akade belekelela konke lokho ukuthi uSiyanqoba ugcine uSiyanqoba ophilayo.
As a farm occupier who lives in Orange Grove Farm, I would like to talk about an organization or a community structure that is called Siyanqoba Rural Transformation Forum.
Okay. uSiyanqoba isakhiwo esakheke emaplazini kubo bonke omasipala abakhele uMgungundlovu.
Siyanqoba is a structure that was established in the farms of uMgungundlovu district.
uSiyanqoba unekomiti elisebenza phezulu kwi-district esilibiza nge-district committee, kube kunamakomiti aphansi akwi-local committee lapho behlangane khona kuze kwakheke ikomiti elizokwazi ukusimela phezulu kwi-district libuye li-reported back kuma-local committee ngokuhlukana komasipala.
Siyanqoba Rural Transformation Forum has two structures within it. One is the district committee and the other is the local committee. The local committee is where structures from different local municipalities in the district where they meet to discuss around their issues that they face and then report to the district committees on a regular basis.
Liqale kanjani ke leli komiti ngokuthi kubonakala ukuthi abahlali basemaplazini bayasalela emuva ezintweni ekufanele ukuthi zenzeke kubona njengokuthi kunama services afanele aphume kamasipala eze kubona bona bakuhlezi besalele emuva and nezinga lokuhlukumezeka kwabo belibukeka likhuphuka unyaka nonyaka.
Siyanqoba Rural Transformation Forum was established as a result of the many issues faced by farm dwellers, such as the lack of services and violations on farms, which has been escalating ever since.
uSiyanqoba uthe mase lakhekile ke leli sisakhiwo kuSiyanqoba kwenzeka kanje kwathathwa uAfra as abantu abakuyibo aba-approacha umasipala bonke abakhele uMgungundlovu ukuthi kwakhiwe lesi sakhiwo ngokubambisana nomeya nabaphathi bamasipala.
Afra approached the uMgungundlovu district municipality officials and other leaders such as the mayor to let the
It seems we've lost Mpumi and Mlu. So I'm going to suggest we go on and, oh, you guys back, sorry. So yes,
Okay.
Please carry on. Sorry about that.
Okay, thanks. Uthe uAfra ke usuzakhile ke lezi usuyakhile uSiyanqoba usufomekile uSiyanqoba waqala ke kwenziwa wasenzela ama-training lapho sikufundiswa khona ngama-rights ethu nangama-services efanele siwathole emaplazini ngoba into ebiyenzeka ukuthi ama-land owner ayawazi ama-rights abo nawo bayawazi futhi ama-rights abahlali basemaplazini kodwa ngokuthi abahlali basemaplazini abawazi ama-rights abo ngokuphelele ingakho begcina omunye esigcinezelwa ngoba engalazi ilungelo lakhe okuyilona lona elisebenzayo njengoba ungumhlali waseplazini.
Following the establishment of Siyanqoba Rural Transformation Forum, there was a training that was held on the rights of farm dwellers. This was because landowners knew their rights as well as the rights of farm dwellers, but because farm dwellers were not fully aware of such rights, there were often violations of such rights.
Uthe sekwenzekalile ke lo ma training sesinalo ulwazi ngamalungelo ethu. Into eyenzakalile ke sibonile ukuthi kusaqhubeka kusebenzeki kahle ngoba khona izinhlaka esingazithulanga kuzona. Sidecide ukuthi okay kufanele sizithuleke manje kumasipala bonke umasipala wazi ukuthi kunabantu abanje abazibiza ngosiyanqoba abangaphansi kwalowo masipala, for example uMkhambathi, bese ukuthi labo bantu labo ibona bathatha information from the ground bayise kubantu abadila ney'nkinga zabantu kumasipala, including ama-council nawo fanele azi ngoba inhloso ukuthi asizile thina ezosiyanqoba ukuzophazamisa umsebenzi wama-leadership abantu abakwi-political ngoba abantu abakwi-politics isikhathi esiningi if usebenza usiza abantu abaningi ubukeka ngathi wena usuzophazamisa indlela yena sebenza siyabonga sikhona and inkinga zethu zicela ukuthi nisisebenze ngale ndlela le ukuze izisheshe ukusebenzeka ngoba uma meqhamuka inkinga kuphuma kuqhamuka from kamasipala inkinga ikisheshe ukusebenzeka ngoba kunezinhlanga ezikhona lapha eziphezulu kamasipala ekubanga ukuthi ezodala ukuthi inkinga isebenzeke ngokusheshsha. Yizohlanganisa sazithula futhi emaphoyiseni okuwabantu okuyibona abathi mekuney'nkinga emaplazini bagijime babizwe kuqala ngokuthi nabo ngathi abanako ukuqonda ngama-right abantu basemaplazini kube yibona futhi abahlukumezayo. Even nama-security company sas-introduce futhi kuwona ukuthi kunethimbe elinje elisebenza elidila ney'nkinga zabantu basemaplazini.
Trainings on rights violation. A decision was taken to present information from the ground to relevant municipal duty bearers such as councillors. As Siyanqoba Rural Transformation Forum, our aim was not to politically influence or interfere with the dealings of the municipal work, but rather to inform them about the existence of Siyanqoba so that the information that we get from the ground and the violations that we get from the ground are reported through these municipal officials so that they can be resolved efficiently. Another structure or an organization that we reported such violations was the South African Police Services, whom we realized that they were also unaware of the violations as well as the rights of farm dwellers.
Okay, guys, do you hear me?
Yes, we can hear you, but I think if you are able to switch off your camera, keep your camera off, I think the connection will be better, but we can hear you.
Okay, thank you. Okay, into esi-achievile ke ngalesi sakhiwo sikwazile uku-achieve ukuthi iy'nkinga zabantu noma zingakapheleli zingakasebenzeki zonke ngokuphelele, kodwa sikwazile ukuthi ey'nkingeni ebesibhekene nazo ngoba kuney'nkinga ebesibhekene nazo ngizozibala nje ngokulandelana kwazo. Besingenawo amanzi akuclean, ugesi, ama-road access, RDP houses, proper sanitation and clinic visitation and wages. So zonke lezi zinto bezingakhona, ezinye zazo ziyaqala ziyakwazi ukuthi zingene noma esekhona ke ama-challenges ukuthi amanye ama-land owner akakathandi ukuthi basizakala abantu abasemaplazini. Kodwa abanye babo sebayaqala ukuthi babe nalo ulwazi ukuthi abantu basemaplazini bafanele nabo basizakala, futhi umasipala unalo ilungelo, unalo ama-right ukuthi uhambe uyosiza abantu basemaplazini.
What has been achieved through the establishment of Siyanqoba Rural Transformation Forum is that the issues faced by farm dwellers, such as access to clean water, electricity, proper sanitation, clinics, and wages, and some of these issues are gradually being resolved, even though there are some landowners who are blocking the process.
uSenqoba-ke ubeke usuqhubeka-ke nama-training, usizwa iwona u-AFRA kuwo wonke ama-training, ngoba kuma-training esiba nawo senza sure ukuthi wonke umuntu okade attende i-training ubuyela back kuma-local committee akhona ukuthi asho information akade ayoyithola, ulwazi akade bebizwe khona la, bebizwe khona u-AFRA. So lapho ulwazi liyakwazi ukuthi wonke abantu abahlali basemaplazini balithole lonke ulwazi ukuthi kwenzakalani uma kukhona inkinga, ku-attendwe inkinga ngendlela e-right, ngokubambisana nabanye omasipala. Zikhona-ke inkinga ukuthi abanye omasipala nabo abakathanda ukusebenzisana, abakayinaki indaba yabantu abahlala kakhulu emaplazini. Abantu abagcina sebenakwa abantu abahlala endaweni ezisemakhaya nendaweni ezisema-suburbs, basala basemaplazini.
Siyanqoba Rural Transformation Forum continued to have the trainings with the help of AFRA. The procedure was that all information received from this training was to be shared to their respective communities in order to pass on information such as right violations so that they can be resolved through a multi-stakeholder approach. There are, however, some municipalities who are not willing to assist farm dwellers, but are more willing to assist people who live in other rural areas, such as those with the traditional authorities.
Njengoba Siyanqoba-ke sengiphetha, siyafisa ukubona njengabahlali basemaplazini sibone nathi sithathelwa iy'nyathelo eziqinile, sibone amalungelo ethu enakekelwa njengabanye abantu, ngoba thina kahle kahle since 1994 asikaze sikuthole ukujabula nale nkululeko ekukhulunywa ngayo, into esingakazi thina siyibone namanje ku-2020 lo, kodwa inkululeko asinayo ngoba sisayile kakhulu. Siyafisa ukuthi-ke sizibone nathi sineqhaza esilibambile komasipala, nawo umasipala unezinto oziphusha phambili eziphathelene nabahlali basemaplazini. Ngiyabonga.
In closing, Siyanqoba Rural Transformation Forum would like to see the rights of farm dwellers being realized, because since 1994, we know nothing about freedom, notwithstanding the fact that we live in a democratic society. Thank you.
Thank you so much, Mlu and Mpumi, for sharing with us what's happening on the grassroots in response to the rights violations on farms. And it was very interesting to hear about the inner workings of Siyanqoba and the hopes that it has for the future of farm dwellers, access to water services and other services on privately owned land. We're going to then now have Simone Gray from the LRC, who will be taking us through the legal strategies and telling us more about the Mshengu case, as I'm sure a lot of people would want to hear about. So Simone, please go ahead.
Thanks, Kelly, and good afternoon to everyone. I want to really thank the Socio-Economic Rights Institute for convening this webinar, because I think that these are very, very important issues that we need to talk about. And I think firstly, just to reflect very, very briefly on the past two speakers, Sia from AFRA and uMlu from Sengoba, just to say that they are the real heroes in this struggle. We as the legal representatives, we just take that information and we use it to go to court, but they're the real ones that are doing the groundwork on the ground, that are really the heroes in the story. But in terms of the legal strategies and the role of public interest litigation, because that's what I've been asked to talk about, I'll take you kind of briefly through what we did and how we were able to achieve it, and what the sort of key strategies were that we used in order to convince the court that this was the order that we needed. So initially, obviously, as Sia has spoken about, there was a lot of engagement with municipalities, with various branches of government, and there was really no response. Despite engagements, there was really no traction in terms of providing access to water, access to sanitation, and access to refuse removal for people that are residing on farms. And so eventually we realized that there was actually no other way that we could go about it besides litigating. Initially, we started by addressing letters to the various municipalities, to COGTA, and even asked them to come and have conversations with us and sit with the farm dwellers and develop plans and say, well, what can we do? How can we achieve these goals? And we didn't get any response to that. So the only thing we could really do then was to litigate and to go to court, which is exactly what we did in the uMshwathi case. And I think there's four sort of major strategies that I'll talk about in terms of the litigation strategy that we used and what was good and what was useful in terms of achieving the outcome that we really wanted. So I think the first strategy that was really, really important was for us to use an institutional client as an applicant. So we used obviously AFRA because we'd worked very closely with AFRA. And it was very important for us to have them as a client because they could provide us with a lot of research data, a lot of information about what was going on the ground, which we as attorneys didn't necessarily have. So that was one of the reasons why we wanted to use them as an institutional client. But also in general with rights-based litigation, we often find that the people that are actually marginalized, the vulnerable people, the farm dwellers on the farms, are in very vulnerable positions. They are working for a farmer and they often are very scared to be part of litigation or sign affidavits because they don't know what's going to happen. You know, the farmer could decide tomorrow that he's going to fire them because they're part of this litigation. And so in order to protect the rights of farm dwellers, often it's much easier, or any other vulnerable community, often it's a good idea to have an institutional client because they can provide a much broader perspective while also protecting those that are vulnerable at the same time. But also we thought about litigating against a number of municipalities, and we realized that we just didn't have the capacity to litigate against more than 3 municipalities, which is what we ended up doing. And so having AFRA as an institutional client meant that they could speak to the much more systematic and broader problems that were actually happening, and look at obviously the right to access those services, but also the broader implications of that and the kind of, as Sia was speaking about, this sort of master-servant relationship that has been created for generations on farms, which really needs to change. So they could speak to that sort of element of the case, which created a good picture for the court as to what exactly was going on. Then the second strategy that we used was to really get a face to the case by adding a human element. So what were farm dwellers really struggling with? I know Sia and uMlu have painted a good picture of what they are struggling with, but the 2 main applicants in our case were really, really struggling. So the first applicant was Mr. Zabalaza Mshengu, who is the sort of the face case, the face, sort of like the face of our litigation. And he was over 100 years old. Unfortunately, he died before the judgment was actually handed down. And he lived in absolutely awful circumstances. He lived in a mud structure on a farm. In order to collect water, the farm dwellers were living on a hilltop, and they would have to put 25-liter jerry cans in a wheelbarrow and then wheel the wheelbarrow down a hill through a bush in order to collect water from a communal tap, and then haul all of that in the wheelbarrow back up the hill to their houses where they were staying. And as you can imagine, someone over the age of 100 is not able to do that at all. So he had to rely on his family and other farm dwellers that were staying there to assist him with that. So absolutely awful, awful circumstances, and just no dignity at all. So then the second applicant was Tabasile Ngema, and one of the reasons why it was good to have a male and a female applicant was because it could also show the court the different struggles that were faced based on your gender. So Ms. Ngema, she lived on a farm where there was absolutely no sanitation. So what the farm dwellers had done was they had built pit latrines in order to be able to have some form of toilets, but what the farmer told them was actually they were not allowed to build these pit latrines. So he told them that instead they must just use the sugarcane fields to relieve themselves, and it would be good because it was a form of fertilizer for his crops. So you can just imagine how awful those circumstances were, very unhygienic, and there were no lights, obviously, in the area around the sugarcane. So as a female, especially at night, having to go into the sugarcane fields if you needed to use the toilet was incredibly undignified and very, very scary as well, possibly. But also every month when women menstruated, when they had their periods, there was no refuse removal. So what would happen was women would not be able to dispose of their sanitary products every month, and they would just have to leave them lying around because there was no refuse removal. And then also had very limited access to water, so were unable to clean themselves properly. And so that applicant really showed, Ms. Ngema really showed what it was like to be a woman living on a farm where there's limited or no access to water, sanitation, and refuse removal. So that was the second strategy, is to show the court really what the human face of farm dwellers looks like. Because reading the papers in court around what these people were actually facing was just devastating. So that was the second strategy. The third strategy was to look at the intersectionality of rights. So even though we were fighting for the right to access basic services, so the right to access water, the right to access sanitation, and the right to access refuse removal, it also intersects with various other rights, and overall creates conditions that no one should really have to live in. So it also intersects with the right to equality, because other people are receiving services and farm dwellers are just completely forgotten by the municipalities. It also intersects with the right to dignity, because people are living in these types of conditions. It intersects with the right to have a healthy environment, because the environments were not healthy at all. No refuse removal, no sanitation, no water. So it wasn't just about those rights, but all of the rights combined, which really created circumstances that meant that those basic materials and conditions that are necessary for human survival, for self-actualization, and for dignity just weren't there. And so the court had to look at how to improve the circumstances of these people and to decide who was responsible for that. So then the fourth strategy that we used, which we use a lot in public interest litigation, was to look at what relief we wanted to seek. So there were three different parts to the relief we sought, and which we were able to actually get in the judgment. The first one was obviously a declarator to say that the conduct of the municipalities was unconstitutional because they hadn't provided access to basic services for farm dwellers. The second part was a mandamus, so to say the municipalities have to provide these services to farm dwellers, and it was detailed exactly what type of services they had to provide. So not just they had to provide water, but they also had to provide a specific amount of water in terms of the regulations. There were specifications on what toilets they have to provide. In terms of refuse removal, how often does it happen? How far do people have to walk to get water? So all of those things were specified. But the third part, which was a strategy that we use a lot in public interest litigation, was a structural interdict, which essentially means that the court has a sort of supervisory capacity, because the respondents, in this case the municipalities, will have to report back to court. So the court said what the municipalities have to do is they have to develop an action plan and they have to develop a report. In the report, they have to look at all the farm dwellers that are in their area of jurisdiction. They have to tell the court how many people have access to water, how many people have access to sanitation, how many people have access to refuse removal, and what is the quality of the water, what is the quality of the sanitation, what is the quality of the refuse removal, how far do they have to walk in order to get those services. And then if people don't have access, they have to provide an action plan on how they will provide access to those people. And in that way, it creates a sort of supervisory capacity of the court to be able to supervise the implementation of the order. And it also makes it much easier for us as applicants to go back and say, well, these municipalities are not complying and the court needs to direct them to comply further. And so those were kind of the four strategies that we used in terms of the uMshwathi case to get the judgment that we wanted, which was essentially that municipalities have an obligation to provide basic services to farm dwellers. So I'm going to move on quickly because I think I'm probably running out of time, onto the second part, which I was asked to speak about, which is the role of public interest litigation in rights-based struggles. And I think sometimes public interest litigation can be very, very useful. Obviously, it's always a last resort. You don't immediately go to litigation. You always try and negotiate or facilitate some form of conversation in order to reach the outcome that you're looking for. But it can also be very, very useful. So the first thing that was very useful about the uMshwathi judgment is there was this conflict between farm owners and between municipalities. Municipalities said, we can't provide the access to basic services for farm dwellers because the farmers won't allow us access to the property, it's private property. Farm owners would say, we don't have an obligation to provide access to basic services, we aren't the municipality, sorry, we're not providing access. And what this judgment did is it said that municipalities have an obligation, a constitutional and a legislative obligation to provide services, access to water, access to sanitation, and access to refuse removal for all farm dwellers. And this means that the judgment essentially can be used in two ways. It can be used firstly by municipalities to actually access private property, to say, look, this judgment says that we have to provide these services. We have a constitutional and we have a legislative mandate to provide these services. And also there are other legislative measures, for instance, in terms of ESTA, which say that a farm owner can't unnecessarily not allow the municipality to access the farm in order to provide the services. So the judgment is also useful to municipalities because it allows them that space to be able to actually go into farms and provide the services. But then second to that is obviously the advocacy part of this judgment, is that it can be used by farm occupiers and farm dwellers and activist organizations to really compel municipalities to provide the services that they should be providing. And you know, we've had very successful, after the judgment, we've had very successful dialogues and stakeholder engagements where we've had municipalities, we've had different people from government, we've had farmers, we've had farm dwellers, we've had all sorts of people that have engaged in these dialogues and stakeholder engagements and spoken about this right to access basic services. And it hasn't been an adversarial process, it's been a process of municipalities kind of coming together and saying, well, okay, there is this judgment in place, how do we work together in order to provide these basic services? So that's also been a positive. But then another positive, I think, in terms of using the judgment as an advocacy tool, is that it can be used in budgeting and decision-making processes at local government level. And this has already been done by AFRA. They've already commented on uMgungundlovu's IDP and said, well, you aren't providing for access to services for farm dwellers, and the IDP was revised. So it's the same with any municipality. When it comes to budgeting, when it comes to their IDPs, activists or organizations can use the judgment to comment on the IDPs or the budgeting and say, well, hey, you know, you've forgotten about farm dwellers. You need to budget for access to services for them. You need to put this in your IDP because it is your obligation to provide these services. So that's, I think, the other really important and valuable role that public interest litigation can really play, is once you get that judgment, is to use it as an advocacy tool. And even though in this case, it was only in KwaZulu-Natal and it was only 3 municipalities, this can have an effect in all municipalities in South Africa. I mean, we've had queries from municipalities in the Western Cape. We've done workshops in other parts of KZN, and municipalities have really sort of come to the party and said, well, what does the judgment say, and how can we use it? And that's not to say every municipality will be like that. And that's not to say that it's not going to still be a struggle, because it is. It just means that at least there's clarity now. At least we know that we can use this as a tool to say, municipalities, you have an obligation to provide basic services for farm dwellers. Yeah, so that's all I have for now, but I'm looking forward to further engagement and any questions that anyone might have. Thank you so much.
Thank you so much, Simone. It was really insightful that you gave a very detailed picture of the legal strategies that LRC adopted in the uMshengu case, as well as your views on the use of public interest litigation in realizing rights-based struggles. We're going to change direction a little bit and explore a potential implementation mechanism for communities who are seeking municipal services on privately owned land. This is the idea of a water services intermediary, which didn't feature much in the uMshengu case, but is worth consideration for other communities who are facing the same challenges. So I'm going to hand over to Lisa Chamberlain, who will be speaking about this idea of a water services intermediary. Thanks, Lisa.
Thanks, Kelly, and hi, everyone. I want to pick up where Simone left off, because I think the accumulation of this panel has led us to this point, which is really that the fundamental question when we're talking about water services provision on privately owned land is who bears the obligation. Do we look to municipalities and local government, or do we look to private landowners, in this case, farm owners? And by way of introduction, there's just 2 things that I want to say about why it's important that we should focus on landowners as part of a conversation like this. The first is, as we know, and as other colleagues have very kind of eloquently spelt out for us, that in South Africa, historically, farmers have benefited from the exploitation of black labor. And while we know that farmers are not a homogenous group, and it's important that we don't demonize them, the key thing here is that the actions and responsibilities of a particular individual or a particular farmer is not always the point. That what we're dealing with here is a historical pattern of systemic inequality and injustice. And when we're part of a system that has caused suffering and human rights abuses, we must also then be part of the project of deconstructing that system and reshaping it in a more just and equal way. And the second thing is that this is not just a matter of moral responsibility. One of the things that makes the South African Constitution unique is that it provides for a system in which rights can be claimed not only from the state, but also from private parties. And so Section 8.2 of the Constitution places responsibility for the realization of human rights on the private sector as well. So with that context in mind, how might we involve private landowners and farm owners in particular in the provision of water services? Well, the good news is that the Water Services Act, which is one of the primary pieces of legislation which is relevant here, proposes a way for us to do that. And the Act introduces the idea of what Kelly referred to as a water services intermediary. An intermediary is someone who has a contract with someone else where the provision of services is implicit in that contract, but is not the main purpose of the contract. So that's a lot of legalese, just hang on and stay with me. In this example, what we're looking at here are situations where a farmer has an employment contract with an employee, or perhaps a lease agreement with a labor tenant. And that would be enough to meet the definition of a water services intermediary. Because one, there's a contract. Two, involved in that contract is the provision of services, because part of the contract is also the provision of accommodation and therefore also services. But three, the main purpose of the contract is not the provision of those services. It's the employment or tenancy relationship. So once a contract like that is in place, a farm owner can become an intermediary. And once that happens, certain consequences attach in terms of the legislation. And that's important because the fact that the obligation is founded in the legislation is important because it can then be enforced by a municipality, regardless of the fact that the municipality might not be a party to the contract between the farm owner and the farm dweller. And the Water Services Act provides for a system in which water services authorities must pass bylaws which cover the conditions for the provision of water services. So that's a kind of general obligation, which is always the case. But in relation to water services intermediaries, it provides specifically for the opportunity for municipalities to regulate what level of services they're expecting intermediaries to provide, who bears what rights and responsibilities, and exactly how the provision of those kind of services is going to be funded. Because in terms of, one of the key questions that people always ask is that what form must services be provided? We know that in rural areas, we're really outside of the realm of piped reticulated water supply. And often water is being drawn from, from dams or from boreholes, that kind of thing. And the Water Services Act again provides us with some guidance here and says that when a water services intermediary is providing services, they have to meet any minimum standard which has been prescribed by either the minister or the local government. And as some of you may know, in South Africa, we have a prescribed standard which is quantified. That standard is 25 litres per person per day, or 6 kilolitres per household per month, within 200 meters of a household. So where you've got people who would, regardless of who bears the obligation to provide water, who would qualify for that free basic water supply, they're entitled to get that, even if the entity providing it to them is an intermediary. So it's a pretty kind of drastic system, if you like, and people get quite uncomfortable when we're talking about placing such extensive obligations on the private sector and on farm owners in particular. And so to that end, we also need to have a look at how that kind of water service provision by farm owners might be financed, because this could potentially be a very big ask from an intermediary. And it's important to make sure that the implementation of the intermediary system, if that's the chosen way to go, is financially viable. Helpfully on this point, the Department of Water and Sanitation, or DWAF as it then was, has promulgated a guide on this, which proposes that when landowners are involved, what municipalities need to do is draft a funding framework for the provision of water services, and also emphasizes that there are quite a range of incentives and subsidies which can be worked out between an intermediary and the municipality concerned, which can help fund both the installation of infrastructure and its maintenance and improvement. So those can include things like the equitable share, the municipal infrastructure grant, which is all kind of discussed in more detail in the publications. So it's an interesting opportunity. There's lots there to potentially work with. Hasn't really been tried very much. Certainly there are very real challenges that would arise in trying to implement the system. And a couple of them, just to touch on them briefly. Firstly, the more municipalities demand improved service provision from landowners, the greater the incentive for the landowner to scale down the provision of accommodation, because it just becomes too much of a bother. And so we don't want to have the unintended consequence of actually making things worse for farm dwellers, placing their tenancy and their occupation at risk of eviction, for example. Secondly, the intermediary system only operates where there's a contract, because that's its very definition. And so where you've got farm dwellers who are living on farms without a contract, either without an employment contract or because they're not actually workers but family members, that kind of thing, we might get the sort of somewhat bizarre situation where a farmer is an intermediary in respect of some of the people living on his or her farm, but the municipality retains responsibility for service provision in relation to others. It's definitely an area which needs to be explored more, how we resolve that. But probably at least part of the answer is provided by Esther, which I think Kelly mentioned earlier, does go sort of some way to giving us some guidance here. But perhaps the biggest challenge is that making a system like this work is very heavily dependent on the Water Services Authority having passed bylaws. All of this hinges on bylaws. Bylaws are where you regulate this kind of relationship. And frankly, dealing with water services provision on private land in this way, because it requires proactive action, might just, given the extent of the demands on municipalities across the board, and even more so now with the additional constraints and challenges imposed by COVID-19, might just not be a priority. And that might be one of kind of key challenges. There are oversight mechanisms in the legislation. I won't go into detail now, but there is provision for municipalities to oversee water service provision by intermediaries, because at the end of the day, the buck still does stop with the municipality. Even if they are choosing to implement the intermediary system, they still bear ultimate responsibility. And so there are kind of mechanisms which allow for them to do that. So really the Water Services Act makes space for a system in which intermediaries are responsible for service provision, both in terms of the technical provision of water services and for paying for some of it. And it allows municipalities to regulate a system like that in its bylaws. And in that way, the municipality can retain both quality control, oversight, and also establishes mechanisms with which municipalities and intermediaries can work together to access money in the form of various municipal grants to support service provision on private land. As Kelly said, this wasn't, the intermediary system wasn't a big feature in the Mshengu case. It wasn't argued in that way. Simone referred to the kind of strategic decisions that often get made in public interest litigation. And really the driving force behind this litigation seems to have been, more simply to get water and other services to farm dwellers. And so I imagine it's quite likely that the legal team had to sort of weigh up the options and decided that the best chance of doing that was to target the litigation at the municipalities directly rather than at the farm owners. But we raise it here because, certainly if I was a municipal official, this is a route and a mechanism that I think would be worth considering. Thanks, Kayla. I'll leave it there.
Thanks, Lisa. So that's it from the panel for now. It was a very rich conversation, and we heard about the challenges of farm dwellers who are living on land that they do not own. We have heard about the ways in which farm dwellers are organizing themselves in response to a lot of these challenges. But we've also just heard about the different ways to realize rights to access to services on privately owned land through litigation, but also through this idea of a water services intermediary. And so we're going to start the Q&A session now. So please continue to add questions in the chat. But before we look at the questions, I'm just going to hand over to Kaya Sithole, who is a political commentator on land rights and an activist. So Kaya, I just wanted to ask you, what do you make of this discussion? And tell us, in your experience, what are some of the obstacles to achieving tenure security and access to basic services for farm dwellers living in the KZN region? And I see that Kaya is joined as a participant. And I'm just going to ask Ed if it's possible to unmute Kaya so he can share with us.
Can you do without seeing my ugly face?
Sure. Thanks, Kaya.
Thank you for allowing me to obviously participate in this very important conversation. And I suppose that the crux of it all is the fact that we know that in the South African story, far too many people's security in relation to land rights and security of tenure remains very fragile. And of course, this is something that should have been a priority for the political elite for a very long time, but it hasn't been the case. And I think what we are now discovering is the fact that some of the issues that some of us may have encountered in our silos or in our corners are far more universal than what we thought they were. And of course, it becomes now that the government has undertaken the process of going through the whole land reform panel and coming up with recommendations, and then at least in principle committing to doing something about the issue of land. It becomes important for us to continuously engage with most affected people, because that informs the quality of our deliberations and the substance of our deliberations that then become the inputs into what the state might do. And I think obviously being able to listen to a lot of people that experience these issues on a daily basis on the ground is an important and a very humbling experience, because I think some of us would have thought that some of the issues that we hear about are were solved long ago. But of course, the reality for far too many South Africans is completely different to that. So I do think that it is a critical and a very important engagement platform. And I think also some of the obstacles that we've seen in the past are probably more bureaucratic than anything else, in that for as long as the state doesn't regard the issue of the Department of Rural Development, for example, as a priority area, it means that in the budget allocation, they are not a priority. And the consequence of that is that you end up not having the right resources that are able to do the type of work that is required at the right scale and at the right pace, because the question of pace becomes very important when people are reaching the end of their lives and they've never actually had security of tenure, because you know that gives them a sense of dignity when you know that nobody is ever going to come up and dig up my grave in 2 or 3 years' time when the government finally resolves the issue of land. So it becomes important for us to keep the government in check, to keep the pressure on. And I think the more of these engagements that we do, the closer we'll get to getting them to understand. Now, whether that translates to substantive changes in the fate of so many marginalized people in the different parts of the country, in the different farms, remains an elusive concept, and the best we can do is simply keep engaging and keep pushing in institutions where we can. And I think also the one important element is that we now know that litigation is an important instrument of getting the state to react, of getting the state to do things right, because at some point in time, the fear of getting arrested seems to be the thing that drives politicians or moves them a bit forward. Some of you may have noticed in a couple of weeks ago, there was a judgment from the land court that still insists that the previous Minister of Rural Development, must be personally held liable for the costs relating to the District 6 matter. So she disputes that. She says it was a departmental thing, but the acting judge of the Labour Court, Toby, insists that it was only because of her inability to take the matter seriously that it ended up being entertained by the court. So he still insists that she must pay the cost personally. And that's an important step, because far too many people simply know that they can do things wrong, they can delay doing the right things, because the worst thing that can happen is if you sue them, you as the taxpayers are going to fund that litigation anyway.
Thanks, Kaya. I think we've lost you. I don't know if you're finished.
Yes, I'm
Perfect. Thanks so much, Kaya. So Lisa's going to put up some of the questions that were presented in the Q&A. But before we go there, maybe let me throw a question to Sia and Simone, just in terms of what Kaya has just said, that there are bureaucratic issues and there is a need for, some capacity building for a lot of municipalities, and that these are, obstacles to realizing the access to services on privately owned land for many communities. And so for Sia and Simone, maybe you can start us off before we look at the questions. How much faith do we have in the implementation plans from the municipalities that the farm dwellers will indeed receive these services, given the obstacles that have just been described by Kaya?
I don't know who's going first. Yeah, do you want to start us off, or should I start?
Please go ahead.
No, go ahead, Simone.
Yeah.
Okay. So I think for me, So it's tricky, obviously. Obviously we do understand that there are always these bureaucratic challenges. The unfortunate thing with the Mshingu case is what happened after we received that judgment was that the uMsunduzi municipality lodged an application for leave to appeal, which was never set down. So it just seemed to be a sort of delay tactic on their side. And what ended up happening was because of them having lodged that application for leave to appeal, it suspended it suspended the order, and the order was obviously to file the plans and reports. And so what we then had to do was to go back to court and bring an application in terms of Section 18(3) of the Superior Courts Act, which would provide that the order would continue to operate pending any appeal processes, because actually nothing would have got done without us having brought that application. But in the interim, COVID happened, the courts closed, we weren't able to bring the application, and it was actually only in August, unfortunately, that order was granted. So we are actually still in the process of struggling to get those plans and to get those reports. So definitely, I mean, the bureaucratic process, the fact that there's lack of budget, all those things do play a very big role in this. But I think having conversations like this, using these sorts of judgments as tools can still be useful. And I don't want to be a defeatist and say that it's not going to get done. We'll get it done. It just might take a bit longer than we expect. And if they don't comply with the order, then we'll just have to get them to comply. And we've seen, I know Sia just mentioned it briefly when he was speaking, but in the Mwalasi case, which dealt with the processing of labor tenant claims, look, there was years of litigation, but eventually we got a special master appointed who then is now overseeing that process of he's overseeing the department to process the labor tenant claims. And that's a huge step in South Africa, to say that the department is just not functioning, and we actually need an external person to come in and actually then supervise and monitor and ensure that that they do the work that they are supposed to do in order to achieve the land reform that we need. So I think it's about coming up with creative solutions. I think it's about engaging more with government as well, because I know personally as attorneys sometimes we don't engage with government. Our first option is always to run to the courts, but I think it's difficult for any human being to really read those stories or go actually to a farm and see how people are living and to throw up their hands and say, I'm not going to do anything about it. And I think that's the power that we have, is to actually say, well, if you're not going to do anything, why don't you actually come and see how these people are living? Why don't you actually come and see what's happening? And that in some ways that could be a creative solution to get government moving. But again, obviously there's budgetary concerns and constraints, especially with COVID-19, which we do understand. But look, we just have to remain positive and keep fighting.
Thanks, Simone.
Sure.
Thanks. I don't know if you want to come in, Sia?
Just a quick one. I think it's important. I've invested a lot of time in trying to make municipal officials understand that as much as we all understand litigation to be an adversarial process, but we've taken time to make municipalities understand that what this case wasn't against municipalities, it was for legal clarity, which also assists municipalities. So I'm glad that the majority of the respondents have understood it in that way. So where I'm confident that there will be movement, yes, we mustn't be naive and say things will change overnight. But where I'm confident is that we are being engaged by the respondents in this matter, who are now calling for support. And we have been very clear that we brought this case not only to expose municipalities, but to help, to give a helping hand and put our proverbial shoulder to the wheel. And we have data, we have relationship with communities, in farming communities. We have contact details, we have networks where we are willing to assist. And we started the process to assist municipalities. And secondly, where I also get my confidence from is that municipalities beyond this litigation have been in contact with us, as Simone says. That there are municipalities outside of uMgungundlovu district who are saying that this court order actually gives them clarity that they need to kind of develop their own service delivery framework in privately owned land. So that's the confidence in that there will be, it will have impact as we go. But the important thing is that, you know, these things often sit lying on pieces of paper. The important thing is that it's platforms like this where we need to ensure that the whole country is aware of such developments, that the town planners in every single municipality. I was very happy.
We've lost you, Sia, but I think everyone has gotten a picture of what you wanted to share. And thank you to you and Simone for sharing, you know, the fact that part of this capacity building process can come from, you know, civil society organizations being involved in cases such as the uMshengu case. There was some activity in the chat. I just wanted to read one of the comments that was made. And this comment was from someone from Bogoto. So this is from Kayo Ndlela from Bogoto, which is a structure set up to amplify women's voices. So Kayo says, women living on farms are still oppressed. We are oppressed in clinics. We have to fetch water from far-flung places, even when we are pregnant. In some cases, we do share water sources with animals, and we do not have toilets. So thank you so much for sharing that and giving us, I think all of the panelists have been trying to give us a picture of actually what is the reality on the ground. And thanks for that comment, because that really gives us a good picture of some of the challenges that are happening. Another comment was about, you know, the COVID-19 crisis and the challenges that this is bringing. This is from Samke from AFRA. And she's talking about, you know, the need of having enough clean water on farms to be able to, you know, meet to be able to actually counter, or to be able to wash your hands to counter the spread of COVID-19. We have other questions. Yes, we have other questions on the chat. I'll just go to the question by Lauren Royston, which is regarding the intermediaries. She says, the district bylaw contains the intermediary provision. Can ESTA be considered in contractual terms as in some way? It might be useful to hear from Sia or Mpume about the conversations we had in the services task team about this option. I recall two important issues. The farmer interest did not want to be regulated by the requirements in the district water services bylaw. We were concerned about the contract requirement. Lisa spoke to the lease agreements and contracts of employment. What about the majority of farm dwellers who are ESTA occupiers? Do the lawyers see ESTA rights as having some legal authority with respect to the intermediary role? So I think this question is from Sia, but Mpume, please feel free to add your thoughts as well as Simone as well in terms of this question, is that, you know, can ESTA be considered in contractual terms, in terms of this idea of an intermediary? So I'll just hand over to, I think we'll start with Sia, and Mpume, please unmute yourself if you want to share, and Simone, you're also more than welcome to give your views on this question.
Okay, thank you, Lauren, for the question, and good to hear from you. I think Lisa touched on the difficulties, the challenges that the services intermediary comes with. And in our engagement that Lauren is referring to with landowners, one of the concerns maybe it came out by reading between the lines, but one of the concerns was cementing the rights of farm dwellers. I think we need to understand that the majority of landowners do not want to confirm the rights that occupiers have on their land. That's due to many reasons, whether it's around claims that have been lodged, around the fear to lose the land, around fear of expropriation, and many other things. But I think it's our experience, and I think the majority of research does show that people continue to get evicted from farms. And that for me is just landowners preferring that there are no other rights on the land that they own. So unfortunately, when it's interventions such as this one, where you're calling on a farmer to proactively engage with the process of giving more rights to occupiers and farm workers and labor tenants, it's a very difficult thing indeed. And in my experience, the majority of landowners really shy away from such. But I think Lauren is raising a good point here about the reading Esther in terms of in contractual terms. Now we know that Esther, in order for Esther to protect occupiers on farms, that occupier must have consent, whether implicit or explicit, but that occupier must have consent from the landowner to be on that land. And for me, that's a contract. And I think I would push our lawyers to kind of try and influence the interpretation of Esther so that farm dwellers are seen as people in contracts with landowners as per the definition of the relationship by Esther. And for me, then that would mitigate the situation where the majority of occupiers are left out as not having contracts. So for me, that's what I would ask our lawyers to look into.
Thanks, I don't know if Simone has anything to share about this question.
I mean, I think Sia's covered most of it. Maybe he's trying to take my job, I'm not sure. But yeah, I mean, I do think there's an interesting argument to be made there that perhaps Esther could translate into some form of a contract. But I'd actually like to hear from Lisa what her views are, specifically because she spoke about the intermediary role, and I'd like to hear from her how, what she thinks about this.
Great, let's have Lisa just answer that one last question, and then we can move on with the program.
Hi, a great question, Lauren. And Sia's absolutely spot on that there's work for the lawyers to do in figuring out how this works. I mean, I have two quick responses. The first is the very unsatisfactory one, that this is definitely the relationship between Esther, the Municipal Services Act, the other legislation like the Systems Act and the constitutional obligations, is not something that we fully understand yet, and which needs more work. A more helpful response perhaps is that I think there might be an equality argument to make here. Constitutionally, it would be entirely unacceptable for an Esther occupier to be discriminated against on the basis that they don't have a contract, because it really kind of it's a very circular thing. The whole reason why people in that situation would need services was because of their vulnerability and their constitutional entitlement to those services. And if the same reasons that they're for their vulnerability are leading to the fact that they don't have kind of any sort of formal contracts or anything like that, we can't use that as a basis to discriminate against them. And I think there might be a sort of plausible equality argument to make to help us do the interpretive work that Sia is suggesting.
Thank you, Lisa. There was one more question in the chat for Simone about the linkages to environmental rights. I'm just going to ask you, Simone, if you could please address this question in the chat. The last panelist that we have for today is Sarah Smith from the Mail and Guardian, who will give us a perspective from the media. So definitely last but not least, Sarah, can you please put on your video and please share with us what you have to say this evening.
Hello, everybody. Thank you so much for having me. I've really enjoyed the presentations this afternoon. I want to start by saying what has struck me listening to kind of Simone's presentation was the intersection between public interest litigation, the strategies of public interest litigation, and that of the media. Number one, kind of giving a face to the issue, then kind of showing the bigger problem and protecting the identities of our often vulnerable sources. But of course, the media, when we're kind of covering these issues, we're kind of scrambling to get the story out there. And we do often make quite bad mistakes. And saying that, I want to say that I think listening to the presentations and reading the case study, I do think that the South African media and media on the left has kind of failed in telling these stories adequately, these very important stories of rural communities and farm dwellers. I think of my own kind of work at the Mail and Guardian, and I really think that I've only just kind of scratched the surface of what is actually happening in South Africa. And that's not me trying to be kind of overly self-effacing. I think it is a kind of problem across the board. And I think, as Sia kind of pointed out earlier, recent events have kind of shown this, this lacking on the side of the media. We have kind of seen in recent weeks how the media has really struggled to articulate the power relationship that happens on farms every single day in this country. So I think that, unfortunately, when it comes to covering these stories, there are a number of issues. Number one, I think, and this is something that I hope the Mail and Guardian is kind of trying to address, is that we're not completely sure who our readers are, and we're not actually sure whether they kind of care about the stories of these different communities. We know that our readers, for instance, in South Africa, in the Mail and Guardian, are primarily Johannesburg-based middle-class readers. And then we also know that if they do care, they are often, we're kind of already kind of preaching to the converted. We know that a large segment of our readership is kind of already aligned to civil society. And this means that we are often kind of in a kind of echo chamber relationship with our readers, which is something that I think we really need to negotiate our way out of kind of urgently. So I think the question becomes then is, how do we kind of join, as the media, how do we kind of join up with civil society to bring power to hold power to account? How do we kind of get in there at the bottom, you know, on the ground, when kind of resources are quite scarce, reporters are stretched? I mean, I would kind of hazard to say that in South Africa, people aligned to civil society or working for NGOs probably outnumber the number of reporters that we have in this country. And they certainly do kind of outnumber the number of reporters who have a specific interest in these kinds of issues and who work for media organizations who are willing to kind of put their name behind pushing for telling these stories. And I think that this means that the media is often kind of on the back foot and kind of playing catch up with the stories that civil society is already telling quite adequately and quite well. But we do kind of need to figure out strategies to kind of get those stories out there, again, to kind of hold power to account. these are big stories, and we need to tell them in a way that isn't us just kind of haphazardly, you know, reading judgments or going to courtrooms because the courtroom happens to be, you know, in Joburg or Pretoria. So it is, again, that thing of getting in on the ground. And I'm very glad that Kaya raised the issue of pace, because we do really need to put this kind of constant pressure on those in power to attend to these matters, because they are urgent. And I think it is vital that we do kind of foster this partnership between civil society and the media. I'm not saying that it doesn't exist, but we probably now have to kind of negotiate different ways of doing it, especially now as we approach the local government elections in 2021. And then I kind of want to bring it back to COVID-19. It's kind of something that is impossible to ignore, especially for us media practitioners, because we know that it has battered newsrooms in an unprecedented way. We're losing committed journalists left, right, and center, journalists that could tell these stories. We're also losing out on very important resources to actually go to communities and actually see what is happening there. And so that we're not only kind of relying on, you know, our friends in civil society to tell us what is happening. But I also want to say that COVID-19 has presented kind of an opportunity for the media, insofar as it's kind of given us this chance to recalibrate our priorities. It has made us think, how do we tell these stories, and what stories do we want to tell? I think that's kind of one of the reasons why we're all here today. And I think also, until most recently, the media has tried very hard to kind of play at political objectivity and not kind of show this kind of activism part of our journalism. But now that's kind of becoming a little bit more difficult as we kind of see the kind of ravages that COVID-19 has wrought all over the country. We have also seen how media's commercial interests have kind of buckled. This means that we can kind of make way for new kind of funding models and different ways to seek out resources that will allow us to tell these stories and cover these stories in kind of new and innovative ways. So I think anybody who reads the Mail and Guardian will know that we are quite, I'll say that we are pretty good at trying to get onto the ground and tell people stories, but we need to find different ways of doing it. Otherwise, we will find ourselves again in that kind of echo chamber kind of situation, and we're not necessarily speaking towards the kind of policymakers that really need to attend to these issues immediately. So yeah, in closing, I just want to say that I think, just as in the uMshwathi case, public interest litigation has kind of ensured that the voices of activists are heard. I think that it is very important that the media kind of steps up to the plate and kind of plays their role. Otherwise, I think if we don't, we do really risk kind of slipping deeper into this sort of irrelevance that we've kind of seen in recent years. Thank you.
Thank you so much, Sarah. That was a great contribution to what has been a very enriching discussion and a lovely way to conclude our webinar. So I'd like to thank everyone for attending this webinar. I hope you have taken a lot you've learned a lot from this webinar. I'd like to thank the panelists. That was a very lovely contribution that each of you made. And I'd like to thank our partners, End Water Poverty and the Mail and Guardian. We have 2 more case studies to launch in this webinar series. So on the 3rd of November, we will launch the Makana local municipality, a provincial intervention in a municipal crisis, on the 3rd. This will be launched on the 3rd of November. And then 2 weeks after that, on the 17th, we will launch Maluti Apafong, a community doing it for themselves. And just like the previous 2 webinars, this focuses on communities using different strategies in a diverse range of circumstances to really fight and access these rights to municipal services that they have under the Constitution. So thank you everyone for joining us. I hope you guys have a lovely afternoon and see you at the next webinar.